Now back to the show. This is The Law Show on CL 650.
Hey, and welcome back. We're talking about estate law, the basic rules when it comes to executing a will. We have John Lakes and John White from LakesWhyte LLP in North Vancouver. Now, John, I think you're just going to give us a little bit of an overarching sort of message about you have to be specific in who you name in the will, right?
That's correct. So when your will is being probated, you're gone. You're not there to give evidence. And it's very important that people can be identified. So, for example, if you wish to leave money to a charity, what you should do is, first of all, almost every charity has a website. So you can go on and you can just have them, you can get the proper description, the proper name of the charity, their address, so your executor knows that it is the BC Heart Association on West Broadway or something. Just like if you're going to name friends who your executor may not even know, you may want to clearly identify who they are and their address so your executor can find them as well. So if you want to go to the effort of leaving money to people, you want to make sure that they can be found when it's their time to receive the check. If not, your executor may have to go to court and say, who am I supposed to leave this money to?
Okay.
No, fair enough. I mean, the court does have mechanisms to figure out what on earth the will maker meant when giving money to a charity if what John has just advised didn't happen for some reason, if the charity's been misnamed, or if there's simply no charity by that name. I talked before the break about a scenario in which the court connected the dots with a very obscure sounding society in the Wesleyan Methodist Church. That was an example of the court figuring out what the intention of the will maker was, which is what the court will always try and do. But there are situations where the court just can't figure it out. There's simply no way to figure out where on earth the testator was trying to leave his or her money. The charity doesn't exist and there's nothing like it. There is an ability of the court to rule that the testator or the will maker was nevertheless showing a generalized charitable intention. That is, they intended to give this money to some charity. We just can't figure out which charity. It's a doctrine.
So what happens then?
Well, it's a doctrine called cyprès. It's one of those wonderful French words that still exists, or French terms that still exist in our law. And the court can essentially receive evidence and give the money to some other charity.
Okay.
But it's got to be in a situation where the court simply can't figure out who the will maker really intended to give the money to.
So you, for example, you wanted to leave money to look for the benefit of cats and dogs, for example, right? So if you don't say the Humane Society or the SPCA, they can say, well, we'll give it to one of those two organizations. Is that sort of an example?
Well, that I suppose is an example. I mean, that is, of course, impossibly vague.
Yeah.
You could argue that's to buy dog food and leave it in the park. I mean, that's an example of a will that simply is failing to do its job, which is to tell the executor where to give the will maker's money.
And it could also be a real nightmare, because let's say if you have to go to court and say, who do I want to leave this $50,000 to? You might have to serve notice to every charity in British Columbia that deals with cats and dogs. Mm-hmm. So you might have, 28 people there with their lawyers, all arguing we should get the money. And then, of course, all their legal fees are paid for out of the estate. So it might cost $300,000 to determine who gets the $50,000.
So make sure you write the name down specifically, the address, and
well, it's not hard.
Yeah.
I mean, it shouldn't be. And if you're planning to make a will, as you should be, we say in this show, surely you can do enough of your homework to figure out where you're leaving your money to.
Okay.
And all you have to do is phone a charity, and they will tell you exactly how to give money to them.
Yes, I'm sure they like that. So residue, for an example, you have a family and you say you're giving 30% of your estate to your 3 children, and then there's 30, 30, and 30 adds up to 90. What happens to the 10%?
Well, the residue of the estate is really important because nobody knows what they're going to have when they die.
Mm-hmm. And
so the practice is divide your estate at the end into shares. And you want to make sure the shares add 100%. So in your example, the problem is if you create 9 shares there's one left over, then it will go as if someone dies without a will, and which means that it may go to people you may not want to have the monies go to. So you always have to make sure the residue equals 100%.
So how can you get that wrong as the
Well,
executor?
Math.
Yeah.
One time it does. Sometimes you want to make your will way too complex too. So, for example, I've had some estates where there's 18 or 19 different residual beneficiaries, and first of all, that's where maybe the math doesn't add up, because all of a sudden you've come to 99.97, and all of a sudden there's 0.03 that is not accounted for. But the other problem is when eventually the executor has to approve the accounts, it means they have to get all 17 people to agree to the accounts. And it has to be 100% approval, which may mean, again, John has to go back to court and say to the court, what are we supposed to do? Because there's 3 people in Bangladesh who don't respond.
Mm-hmm. What do you do?
Yeah. Well, you go to court and tell them there are 3 people in Bangladesh who don't respond, and you seek your order. You know, the court, of course, has residual jurisdiction for all sorts of things, but you know, with respect to things like you know, naming 100 people as residual beneficiaries, I mean, that's absolutely crazy, because it just makes a huge amount of work for the executor and gives each one of those 100 people the right to have a say and to be required, essentially, to have a say on the estate accounts.
So
I mean, why do that?
So give me a common example. What, in your experience, what do you see go wrong in this situation with the residue?
Okay, well, I'll give you an example. So let's say I'm doing a will right now where we have 3 children. Okay, we're going 1/3 to Mary, 1/3 to Susan, 1/3 to Frank. Now, and then we say if one of them dies, it goes to their children. The problem is, although we've corrected it now, much to the parents' surprise, is Frank is not the biological father of, or a legally adopted father of the child he's raised. He's on the birth registration. So in case Frank dies, we've had to include in the residue that if Frank dies before I do, his share goes among his children, and we've named that children.
Mm-hmm.
So that's the first issue. The second thing is, let's say you go ahead and you leave money to maybe to your sister, and she's died before you, and the way you've worded the clause, all of a sudden it goes to your 2 nieces you don't like.
Mm-hmm.
Or else if you leave money to your sister-in-law and you really like your sister-in-law, and then she dies before you do, and you think it would go to her your niece-in-law and nephew-in-law, but it doesn't go to them because they're not really your relatives. So example I had years ago, I was dealing with an estate where half the will was going to go to 2 brother-in-laws. One was getting one was getting the other. Well, one brother-in-law died before this man did, and because my client was very close to the nieces-in-law, but he wouldn't change his will, and he died, and the nieces-in-laws didn't get anything because they're not related to him.
Mm-hmm.
So that share of the estate went to his sister we hadn't seen in 60 years. So you've got to look at the position, not only who's to get that share, but who's the backup if for some reason that person...
It's like an onion.
Yeah. And then the other thing, which we're going to talk about in the next show, is the residue may have funds in trust too, for if a child's under 25 or something. So the biggest problem in the residue is if there's not appropriate backups, if one of the people who was to get a gift has died before the deceased.
John, you were mentioning when you have to get 100% approval from everybody who's benefiting from this will. So you have major players that are getting, big chunks, 30%.
No, you just have to get the approval of the people who are getting the residue.
Oh, the residue.
So you give $10,000 to your neighbor, she gets her check, she's gone.
Oh, okay.
It's just the people that get the residue.
Oh, I see.
But what you don't want to do is give 2% of your estate to that same nephew, knowing that it's equal to the same $10,000. Because if you give them a percentage of the residue rather than a straight cash bequest, then you are giving them the rights to challenge and really your estate accounts. And they've got the standing to be consulted with respect to the estate accounts. And if you have too many of these people, it will turn into an organizational nightmare.
And so can you give us a quick example about somebody had very small standing and held everything up?
Well, I mean, just the one that John was describing a few minutes ago. I mean, somebody who gets 1/96th of the estate. That sounds mathematically precise, and I'm sure somebody thought they were very clever, I think, putting that together. But Mr. 1/96th of the estate certainly had the right not to approve the estate accounts presented to this person. And it only takes one. Unless there is 100% approval of the estate accounts, the executor needs to pass his or her accounts before a court approval or a court official called a registrar. And it's basically like running a trial.
So very complicated. Now, final minute, final thoughts. I think we've covered a lot today, but I think it basically always comes back to make sure the intent of your will is written properly, right?
And keep it simple. So don't make it overly complicated, because at that point it could be a nightmare to administer.
Anything you want to add, John? Even a simple will can be an effective will, and sometimes they're more effective than the complicated wills that we pay tons and tons of money for. Keep it simple. Make sure that it shows and reflects what your intention actually is with your money. All right, it's a great final advice. We are going to pick it up and talking about signing wills and the importance of that in our next show with John Lakes and John White. It's the estate law and estate planning, Lakes LLP in North Vancouver. Thank you, gentlemen, for coming in today and helping clear a very complicated subject up for us today. And I'll be back with the two Johns on a future show here on The Law Show on CL 650.